Welcome to another in a series of NJAPM webinars. I'm Carl Cangelosi, and today's webinar is Family Mediation and the Coronavirus, Practical Tips for Mediators. Today we have a panel composed of three people: Larry Jones, Steve Menack, and Ken Neumann. Larry Jones is a mediator, arbitrator, and professor at Montclair University and Monmouth University. He's a former family part Superior Court judge. Steve Menack is the founding president of the New Jersey Association of Professional Mediators. He's a vice president of the Professional Mediation Board of Standards and a founding member and member of the board of directors of the Academy of Professional Family Mediators. Ken Neumann is a founding board member of the Academy of Professional Mediators, is a founder and director of the Center for Mediation and Training. He's trained as a family therapist and a clinical school psychologist. So welcome to all of you. So before we go into the first topic, let's talk a little bit about how we're going to run the meeting. We have a number of topics, and you're free to ask questions as we go along. So if you go to the bottom of your Zoom screen, you will see a Q&A function. At any time, ask a question. I will ask those questions to the panelists at the appropriate time, and we want to keep this fairly interactive. We're not going to send them all, wait to answer the questions at the end. On the other hand, I have to be somewhat of a timekeeper, so we may not get to answer all of the questions when you might think appropriate. So let's start. The first issue is the impact of the pandemic on litigants and the settlement process. And Larry, that's yours.
Okay, thank you. And greetings to everyone joining us. These are very strange times, but they're educational times. Everybody is learning as we're going. It's a new world. Some say it's an upside down world, but the system has to keep moving ahead. Cases have to keep settling, and people still want to move on with their lives to the extent they can. How has the pandemic affected the settlement process? Well, obviously, it depends on a case-by-case basis. But you can kind of dissect cases into really three categories, the way I look at it. Number one, you're going to have cases which are really not affected that much substantively by the pandemic. Cases where it's relatively simple in nature. For example, two W-2 employees, perhaps their jobs have not been affected by the pandemic. Perhaps they had a short-term marriage. Their issues are straightforward. They just want to settle things up, and maybe the pandemic has not affected what is either their short-term or long-term situation. In that type of situation, you could potentially move ahead with settling the case in rather quick order, using, obviously can't meet in person, but using things like Zoom and forums like this. The second type of case is one where they are perhaps close to settled, perhaps they have some long-term issues, which can't be settled immediately because there are some question marks about how the coronavirus will impact on somebody's income, somebody's housing situation. It may be difficult for people who are planning to, for example, physically separate next week or a month later to do so, because where are they moving to? You can't look around for houses very easily right now. People aren't buying and selling. There's a ripple effect with the market. So you might be able to get on the road to settling the case, but you may have to wait a little bit to kind of close some issues out. And then the third type of case are cases where, as a direct result of the pandemic, there are immediate COVID-19 related issues that are in dispute between the parties that they can't resolve between themselves. Immediate issues such as pendente lite type support, interim parenting arrangements. We're hearing time and time again about issues concerning parenting time. And one parent being concerned about sending the child to the other parent because there's a potential exposure to the COVID-19 virus, or the other parent is exposed to other people who could potentially be exposed, people in different lines of work, the critical force, essential service providers, etc. And those issues have to be addressed immediately in some fashion. A lot of cases, you have a layering of issues. You may have a case where before the coronavirus hit, there were some complications in the case. It was moving along. It wasn't going to be a one-shot deal and get the whole thing done. It's going to take some time. And now all of a sudden, on top of that, there are immediate COVID-19 related issues that did not previously exist, but exist there now. It seems to me, and everyone can obviously use whatever style or order of priorities they choose using their discretion. But there's a logic, it seems to me, to triage these cases so that in analyzing a case, you have to first look at, are there COVID-19 immediate issues that have to be addressed first? If there are and you don't address them first, there's like a domino effect. It makes it very difficult to ever gain a clean settlement on anything because there are all these question marks floating around. If you address the immediate issues first, there could theoretically be an agreement whereby the parties agree at least temporarily to what the arrangement will be until the world can make better heads or tails out of which direction everyone's going in because of the COVID virus. People whose plans were to get divorced tomorrow might have to slow down a little bit. They're going to be litigants, parties who in good faith wanted to get this done next week, their settlement, move on with their life, but they really can't because they don't know if their job's going to be there. They don't know what their living arrangements are going to be. Maybe somebody got sick or infected, and then you have those issues. So there's a whole host of complications which arise from this. But I think a mediator's function is to try to, number one, keep everyone calm during the process and keep it moving forward if both parties are interested in moving it forward. And what I'm finding is, that there are many people who still want to go ahead with the process. They haven't just stopped the process until the world turns right side up again. They're going ahead, but doing it in different ways, trying to do it in constructive fashion. Other litigants, there's a contentiousness which sometimes develops, and they're trying to get into court immediately, and they're not talking to each other, and getting into court now is a little bit of a difficulty. But Steve and Ken are going to talk about some of the substantive things, and as will I, that you can do when you're substantively mediating these type of cases in a COVID-19 world, but it certainly has complicated things along the way for sure.
So Larry, let me ask you a question.
Yeah.
How would you draft a memorandum of understanding, or how would you talk to your clients about that this might be a temporary situation,
right,
will end, and how will you structure, whatever provision it is,
right,
to take
right.
take care of it?
Excellent question. I think psychologically, a lot of times people are, especially if they don't have a lawyer or if they're not familiar with the legal system, they're concerned about committing to anything, especially in this environment, out of fear or concern that it's going to somehow create a permanent status quo, that they're signing it, they're signing it in cement essentially, and it'll be impossible to ever change things. And I think if a document is structured, memorandum of understanding, any type of document, where it's crystal clear that it is an interim resolution specifically in response to the COVID-19 situation, that neither party is in a present position to project long-term what the situation is going to be, that this is essentially an accommodation reached by the parties to have some temporary structure without prejudice to either party's rights to seek a modification at any point in the future without having to demonstrate what in New Jersey is known as a LEPIS change of circumstances, a substantial change of circumstances test. I know there are people who joined us from other jurisdictions. There may be different names for different tests in different states, but essentially, the issue is generally if you sign something, do you have to show a substantial change of circumstances to modify it? And in this environment, you can have an agreement like that. I mean, you can, but nobody's going to want to sign it because they don't know what's going to happen in their own lives a month from now or 2 months from now. But they may be much more willing to do it if the agreement says clear as a bell that this is virus related, that this is the situation as an accommodation. It could perhaps be deemed to be short term with a review after 60 days. During that review period, if everything was working out well, the parties may say, fine, let's keep going. It's almost like renewing a library book back in the day. But on the other hand, if there's a problem which has arisen, there's an opportunity for anyone to modify it really de novo, meaning that you don't have to show any change of circumstances because this was just a temporary situation. And I think if both parties are aware up front that they're doing something only as a temporary accommodation in response to a very catastrophic situation that nobody anticipated, they would be more comfortable, at least in considering different possible interim arrangements that could meet both sides' expectations without having to overcome the fear that they're signing their life away in some fashion. But it has to say it very clearly right in the agreement, sometimes more than once.
So I've seen a number of provisions that people are drafting or have drafted now with respect to using Zoom and the situation we're in generally. I'd like to see some place on the NJAPM website where we can have those as a resource. Could I ask you to draft the kind of language you think would be appropriate to go into an MOU, and we could make it available?
Sure. No, I'd be happy to do that. We had some forms we were doing in the context of court mediations that we presented at some other seminars, and it could sort of follow that template, but I'd be happy to do that. And it would basically be along the lines of what I was just describing. It would be a template. And, you know, quite frankly, it's not even after this circumstance, hopefully sooner than later goes into our distant past and we go back to normal, having a provision like that in a mediation agreement, in an MOU, even on an interim basis, can be very helpful in a lot of other situations. Doesn't have to be just COVID-19 related. But I think if you're really dealing with COVID-19 for right now, I think it helps tremendously to have that in the agreement, because a year from now, if a court has to look at it or someone else has to look at it to interpret it, whether how binding is it, et cetera, it will be clear to anyone reviewing it, whether it's a judge, an arbitrator, anyone, that this was in specific response to this catastrophic event which took place. And it's very similar. I mean, I was telling you, Carl, before we went on, you know, I look at this in many ways as similar to what happened back in 2012 with Hurricane Sandy in New Jersey. I was on the bench at that time. So I was dealing with these cases all the time, custody cases, a change of circumstances cases, support cases. People lost their houses overnight. The cities were taken out. The whole roller coasters were in the Atlantic Ocean. It was just such a disaster. People's lives were really destroyed for a long time. And there had to be some immediate, temporary, logical solutions to things. But there were many litigants who were just afraid that if they agreed to anything, even out of kindness, that it was somehow going to be used against them in some fashion down the line. So you had to be very, very aware of that and mindful of some of the mindsets of litigants who have to proceed or been told to proceed appropriately with due caution. And so putting a document together like that or assisting in that process, I have no problem helping. I'd be more than happy to do so.
Okay. Now here's a question, Larry, that I'm going to ask all the other panelists too. Have you done any online mediations at all, and recently too?
Yeah, I did several last week. And I have to say, it's not the same. This is just my personal opinion. It's not the same as face-to-face. So you do lose something. But I find there's some benefits to it too. Number one, I'm finding, and I was mentioning this to different lawyers last week who I was dealing with, that there is a noticeable calmness to the litigants when it's done in this fashion that I've noticed, that they're not, you walk into sometimes, especially if it's a contentious case, if it's not a consensual type of mediation, like off the court list, that type of thing. I know it might be different when you have litigants who come in privately and they work things out with themselves, between themselves, but you don't always get that situation. And in the more contentious cases, even if you're keeping them separate in a mediator's office or in a lawyer's office or in a courthouse, they sense that the other one is there in some other room. And if they get bothered by it, and if you're spending too much time talking to one side and you only spend half the time talking to the other, then it's construed as some type of favoritism. Sometimes people assume the worst because they're in a very stressful situation. I'm finding in doing it by Zoom, and the way I usually do it is I have them separate, although I could have them together. But they're much more relaxed. Maybe it's because they're in their homes. Maybe it's because they don't have to sit there for a long period of time while waiting for the mediator to go back and forth, that type of thing. Could be a lot of reasons, but I just noticed the calmness. And in cases involving attorneys, the attorneys in this in this particular time, they have a million other things going on too, including sometimes their own child care, and suddenly they're operating out of their home and everyone's life is upside down. So they may not be able to spend, 4 or 5 hours of consecutive time, in an office, as what might happen in some extensive mediations. And so the ability to go back and forth, to rejoin, to come in and out of a conference call like this or Zoom conference, I think provides a level of flexibility that you don't always have in these situations. Now, if you have two litigants who get along great with each other and they come into a mediator's office and they're like best friends who just happen to be divorcing, then it might not make a difference whether you're doing it online versus as opposed to in person. You do have to be familiar though with how to work, how to put documents online so everyone can see it, and how to view and share. And I know, Carl, you're doing a whole webinar next week on Zoom and how that works for people who are not that familiar with it or newbies at it, which is probably a good thing for anybody to attend as well. But I actually like the Zoom mediation so far, quite frankly.
Okay. Second topic is private mediation versus court-ordered mediation. And Steve, I think you're going to talk to that.
Happy to. My practice is very different from Larry's in that, save for 1 or 2% of cases that might be coming my way from the court because someone wants a case to be handled by someone who's had a lot of experience, the vast majority of my mediations are private, professional mediations where couples come to me for mediation services, oftentimes before they even contact attorneys, or have contacted attorneys and they have the attorneys available for consultation, but they want to have their divorces or separations mediated without having to first file in court. So that's the vast majority of the cases that I handle. We as mediators are in the midst of a worldwide pandemic these days, a near lockdown, and to top it off, worldwide financial recession that's resulted from the pandemic and has exacerbated many of its effects. As a result, we private professional mediators, and in fact all mediators, I think, need to be cognizant of two major considerations that are in play and that must be addressed in order for our clients, our practices, and us to be able to survive and to thrive during this new world that we're all experiencing. One is what the current situation is with respect to our clients, looking at that, understanding what's going on with that and how it impacts us. The second, which I'll speak to afterwards, is how we as mediators are handling that and what we can do and how we can do it to maximize the benefit for our clients and for the benefit of our own practices as well. As far as the current situation amongst our clients, we right now in most every state, including here in New Jersey, are subject to stay-at-home orders, social distancing. Many people, the vast majority, are locked inside their residences in very, very tight quarters, and in a situation that many of them have never lived through or experienced of this nature. On top of that, there's a real concern amongst our clients in terms of keeping themselves and their children, their families, safe and healthy, and even on a more basic level, staying alive during this process. Added to that are all of the financial concerns that are resulting from COVID-19. Many of our clients are experiencing a loss of employment. Those that aren't experiencing a complete loss may be furloughed, which means they've been temporarily off the books, and that's creating a number of follow-up issues and concerns financially. To top it off, those clients who had any exposure or investment to the stock market have seen their assets plunge in some cases by 1/3 or more, depending upon their investments. So it's not just the pandemic, but also this additional series of events financially and property-wise that are contributing to their stress and their anxiety. On top of that, given all that they're experiencing at this point, they have lost their normal channels and their normal social outlets for relieving the stress, the enormous stress that they're currently under. They can't reprieve the stress by going to gyms, going to movie theaters, restaurants are closed, libraries, and their ability to even socialize with friends and family who they may have counted on for support has taken on a turn as well. So amidst this very stressful situation, we are finding a number of interesting developments that are occurring as a result. First of all, many divorce attorneys and mediators are seeing more calls from clients inquiring about divorce. It's not, it's certainly understandable. They're locked in close quarters. They don't have options with respect to relieving the stress. And that's making some people consider divorce and divorce mediation where they might not have. And those people who have experienced difficulties with their spouse, you can imagine how that's exacerbated by having the spouse locked in the same house as they are and creating further difficulties. So one thing that we're finding and that the research is pointing out is that divorce mediators and divorce attorneys are receiving an increased number of calls for divorce from couples that had not considered it or had considered it, but it hadn't risen to the level that they needed to place the call to ask about it. Secondly, we're seeing an uptick in domestic violence as a result of people being in close quarters. I've had a number of situations where things ended up with my own clients taking a turn where they contacted me. One spouse had to leave the house because of issues with the other spouse and domestic violence. The restrictions on mobility, the access to shelters, access to being able to move around, go back from one home to another, police services being utilized for other purposes. All of these items are contributing to that, and there is a swelling of clients who are in need of our services as a result of domestic violence as well. Third, we're hearing that in about 8 or 9 months, we're going to be seeing increased births as a result of that. More families with children presenting with a number of different child-related and other issues. So those are 3 of the trends that we are seeing. Now, as I've indicated, there are significant challenges to our clients associated with what they're experiencing. Just as there are significant challenges, I think there are significant, in fact, tremendous opportunities for us as private professional divorce mediators to be able to provide our services that are desperately needed now more than ever, and resolving disputes for clients who currently don't even have the access to the court system, save for emergent situations, and can't and don't want to continue to have their lives and their relationships placed on hold and lockdown and not being able to move forward. That feeling of desperation coupled with the financial desperation is, I think, a tremendous opportunity for us as private professional mediators. My practice has, in the course of the last couple of weeks, been tremendously transformed from a brick and mortar divorce mediation practice where 99% of the clients that I would be helping would be helped face-to-face, and maybe 1% or 2% being helped by telephonic mediations, which I've done as well with situations where there are one couple here, one spouse here in New Jersey, the other out of state. But that has morphed and changed tremendously over the last several weeks to the point that I am now 100% online and helping couples mediate their divorces, their separations, child-related financial and other issues online. That brings with it many, many other changes. I see this as an advantage not only in the short term, where attorneys are not able to file proceedings in court with any expectation or hope that they're going to be receiving a docket number within a couple of weeks with what's happening with the courts. I see this as a tremendous potential boon for mediators. And there are a number of considerations that I will be speaking to with respect to how one can structure your online mediation practice, as well as providing to those who are here on the call with helpful guidelines and tidbits and ideas that you can implement in having a separate online mediation agreement, as well as certain other online features that will be helpful in terms of establishing a successful online practice for all of you. So I'd like to give Ken an opportunity to provide his presentation, and then I'll be circling back with respect to helpful ideas, specific concrete items to be put into a separate online mediation agreement, as well as other considerations with respect to certain other services that I now provide that permit couples to be able to sign documents electronically, and what steps all of you can take toward that end. So I will be happy to provide that going forward.
Steve, let me ask you, go first. Anyone who wants to ask a question, please use the Q&A function, which you'll find down at the bottom of your screen. If your screen isn't maximized, you'll find it under the 3 buttons where it says more.
Right.
So please don't raise your hand. Please don't send a chat. Ask a question under the Q&A function. So Steve, you've done online mediations now. How do you like them versus in person?
If someone had told me last month, you're going to be doing online mediations, much less you're going to be enjoying doing online mediations, I would have looked at them with a very different eye than I do now. I actually love the online mediation practice. There are a number of advantages that I found that it has hands down over the traditional practice. Not to say that the traditional practice won't be coming back, but even after it does, based upon some of the benefits that I'm happy to share, I think online mediation is going to stay and not go away completely even after COVID-19 does. Okay. First of all, I found it to be much safer. Clients feel much more at ease. They don't have to have their spouse sitting next to them. They can see me. They can see their spouse on a screen, see everybody at the same time in a unique perspective that they never could do before when they were sitting across from me, across the mediation table. It's much more convenient. None of us has to leave our offices, leave our homes to go to offices, meet clients at their homes or in other places and other offices. It's much more convenient. It's a much more flexible way of operating it. It makes it much less onerous to be able to offer the services in the evening or over the weekend. especially since our lives with our families have been transformed to such an extent that days, evenings, weekends are blending into one another. I feel a lot less guilty offering clients an evening or even a weekend mediation, because there are other times that I have the benefit of spending with my wife and with my family when I'm not providing mediation services. I also have found, from a practical standpoint, it provides much more in the way of control for the mediator than I had previously. In reviewing memoranda of agreements with couples in person, oftentimes I would be reviewing certain portions, bringing their attention to certain questions that I had, and the wife might be 3 pages behind, still saying, wait a minute, how about this? And the husband is 18 pages ahead saying, let's move this along. We got to make progress. We got to finish this. Get it done quickly. Come on. And is way on a very different page, not only figuratively, but literally, than where I was and where I needed the couple to be. Through screen sharing, and there is a button that says screen share screen at the bottom of your screen, that is useful for being able to upload my memorandum and share it with clients, but to do it maintaining more control over it, page by page or question by question. So I move the screen to the page and to the question that I need to address with them, and everyone is focused on that question. Does it read this way? Does it read that way? And here are a couple of other considerations that I've thought of. How do you guys want to handle this? They're all focused on the same page, on the same language, and are able to be much more present where they need to be, rather than being distracted.
Okay, Steve, are you still getting paid at the end of each session, and how are you doing that?
I am. There are a number of considerations that are different to the practice of online mediation than was the case in seeing clients personally. I now provide several documents to the clients in advance of the mediation. One of those is a request for them to provide a credit card or a debit card where the session can be charged following the mediation. That permits a mediator to be able to be compensated for the time that we spend with them, rather than not having that at all, and then needing to try to chase, which is something I really don't like to do, to ask for the fee to be paid.
Okay, thank you. The next issue is parenting time, including school issues and Ken. And before you start, we have a couple of questions pending, but they really, I think, fit in more with what you're going to be talking about. So I'll ask them either during or at the end of what you're going to say.
Yeah, so and I particularly thank you, Carl. I want to pick up where Larry and Steve left us on mediators' role. And the question really, Steve and Larry and Carl and all of us, is, will in-person mediation ever come back? I mean, I don't know. I was similarly surprised myself, having really never done maybe 1 or 2 mediations by Skype or some such thing, thinking it wasn't genuine, there's something unreal about it. How do you really get the feelings? How do you get the nuances? And I myself as well, as you, Steve, and my practice is like Steve's, private mediations, I was surprised how quickly it felt more comfortable. That I had one situation where a couple I was mediating for quite a long time, and what was taking so long is one of them refused to be in the room, in my physical room with the other one, refused to be in my room at the same time. And now, right away, they were both in the same room, Zoom room, and they were on the screen together. They could see each other full face and me. And so we solved that case quickly because of this. And I should have thought of that a long time ago, and I obviously hadn't. And I was surprised at the new techniques that we learn, and I've been watching those. One, seeing both people, because it depends how your office is laid out, but often you can't look at both people at the same time because of the way one chooses to sit far away at an angle from the other one, for sure. And now everyone sees everyone face to face the way we're all looking at each other, and that gives us tremendous advantages. And I also, by the way, at the end of the session, and these are for existing clients who I've seen person to person, I always ask, how is this experience different than our last session we met in person? And I actually have them talk about it as part at the end of the session typically. And I think that's a very meaningful conversation when they then can talk about it and use that as a way of how they can relate differently to each other going forward. It's a teaching piece, because if they've learned to relate better in this session, how can we use those techniques rather than nasty texting, for example? How can we use these techniques to teach our clients how to relate better to each other going forward, which I feel is always part of our job. It's not just when the mediation is finished, we leave, and now they have another 15 years to deal with each other, notwithstanding they may come back. And so I think this has been a very useful teach piece for me. I've learned a tremendous amount doing this work. One, that I'm comfortable doing it. I may even prefer it in some cases. And it's going to change the way we practice for sure. Most of the people I've seen have been existing clients. And another group of people are former clients who had already been divorced and everything was going fine. And now one of them is in a different place outside of the city. They have a 1 week on, 1 week off schedule. And I've been mediating several situations where one of them says, shouldn't our child come down or up to where I am? It's safer here. Why would you not want that? And the other person says, well, I'm in New York City, for those who didn't know that. Why? Well, the doctors are better here. I mean, the hospitals are better here. I mean, and then you have to mediate things you never thought you'd mediate before, such as where is safety issues, as Larry mentioned. Safety issues are really paramount here. We have a few court cases. There's one from Ontario that's been circulating. Not that any of us are in Ontario, but certainly that's setting a certain stage for mediators and attorneys. We've all seen that case. I assume Larry was shaking his head. Yes on that. So I think we have a tremendous opportunity to use our skills in a different way than we have before. This has been a tremendous opportunity for me and everyone I speak to. We're having our class, our supervised practicum, and we have the couple coming into the Zoom room, and we have the mediators watching it from an observation room. And so it's very exciting to see us talking about this. We may make this available to people in New Jersey as well, because we previously couldn't let more people into my physical office because there are only so much room. So we're thinking of expanding that. Some of the other cases that I've seen, other than the safety ones, and I think this gets to Glenn Milgram's question that he sent in, should healthcare workers be penalized and not be able to see their children because of the possible exposure that may exist by a healthcare worker, for example, seeing their children, and the other parent has raises that question. We're going to have to mediate those things. I've been mediating those things for the last 2 weeks or more, it seems. I don't even know what day is it, Carl? Just so you tell me. Today.
The date or the day?
The day. What day is it?
It's Monday.
Oh, thank you.
It's Monday. I know it because we're having a webinar.
That's why it's Monday. Yeah. The usual cues that we have about what day it is have been lost. I was mixed up in the office 2 weeks ago. I didn't know what day it was. It doesn't matter what the it is. That's the whole point. And what we see, Glenn Milgram's question: should healthcare workers be penalized? Should healthcare workers be penalized? Look what they're doing. That's something we have to deal with. We're mediating that issue. I don't know the answer to that. We don't know the answer to any of these questions. We're mediators. We're going to mediate the couple to come up with the answer themselves. That's our job. Let's be clear what our job is. It's a job we've always had. We don't know the answers. I certainly don't know the answers as to what's safe, but I do know how to mediate that question when it comes up. Should children travel? One client was in New Jersey, one was in the Bronx. Should the child travel back and forth? What are the safety factors? This is what we have to mediate. I often ask people to speak to their pediatrician who they trust and who can give them an answer that may satisfy it. So we have many such situations, and I think the uniqueness of them depends on our clients. The former clients are coming back. We can all discuss later, have we seen former clients who now have a problem because of location or safety? And I think then there's then another group of people that I've come across, which, and I don't know, this is maybe a value judgment on my part, but it appears to me that sometimes someone is taking advantage of the situation, that their claim isn't necessarily a legitimate claim for safety or otherwise. And then the question is, how as mediators do we react to it? We're always aware that we should not include our implicit bias on certain issues, but some of these issues may be, we're talking about life and death issues in some cases, at least theoretically. How are we pulled into that? What is it like when we're thinking of it? Would I let my kid do that? That kind of thing. These are very tough questions that we're having to deal with on a very personal level. And how do we react personally? And we'll all have a chance to talk about this, to a parent where it appears that they're taking advantage of the situation unfairly. And they're saying, well, it's not safe for our child to do this. So I think this has been an unbelievable learning experience for me, for the people I work with at the center, for the people who were training. And I think I'm as tragic as this all is, I think it's teaching us new ways to do our work as family mediators. And I'm excited by it. Once I put aside the tragedy of all of this, the work is exciting. And I'd like, I don't have the answer to Glenn's question, but I think it's something we can talk about. And I think we should now open this up to our talking among ourselves, and then answering some of the questions that Carl has gotten, and share our experiences with each other and with the community.
So let me ask you a question. Let me ask a question that was submitted. I have a client, presumably New Jersey, who was scheduled to go on a cruise to Florida with her son for spring break. Can she drive to her parents' private home where she and the child will seclude themselves? Again, I assume that's in Florida. I don't know. Is what you're saying, can you have no view on that at all? It's whatever the clients want to do. And let me follow that up with a second question is, are you informing your clients that this is what the state is saying? They're saying you should seclude yourself. You have to. In fact, you have to.
Well, I have the same information. Everyone watches the same news channels, and everyone knows what the state has required. I don't think that's a secret. That's Anju's question. Hello, Anju. And I saw that question hop in. I think the question is, we have to mediate it. I'm not here to enforce the governor's rules about this or anyone else's. I'm here to mediate the situation between the parents. Someone has not come to me to consult with me individually as to what I think is safe. If they did, I would certainly give them my opinion if I thought I had an informed opinion. My job is to be the mediator and to mediate between the parents, as I always have, notwithstanding that much more is at stake now, and I realize that. So I don't have an opinion on that, Carl.
You don't have it. Okay. Anyone else have an opinion on that?
Carl, if I could just add something. I can tell you that sometimes it's helpful if litigants who are in a stalemate, such as in the situation you just described, should the child go to Florida or not, that sometimes it's helpful to try to put the litigants in the shoes of what a court might or might not do in that type of situation. And I could tell you that I believe in general, courts are starving to see litigants who are acting reasonably. They want to see people who are willing to act reasonably. And also litigants, sometimes when they take a hardline position, they're doing it in their own self-interest sometimes. They may say they're doing it for the sake of the child, but it's really in their own self-interest. And that being the case, if they're to understand that it is in their self-interest to be a little flexible, to compromise, to bend, to do something that's a little balanced, it may in fact encourage them to reach an agreement when that was not otherwise the case. In the Sandy cases that I would get in 2012, there were many times when I'd see a case where it seemed pretty obvious that one parent was using the Sandy situation unfairly to try to get an advantage against the other side. But there was circumstantial evidence that would support that conclusion. For example, a history of problems with parenting time before the catastrophe. If you have a case now with the pandemic and there's a parent who there's been no problems with parenting time, and this is now a situation which has come up now, and there's a concern, for example, that the other parent works in the health field, the other parent is exposed to people, that will it expose the child? But they have no prior history of being problematic or obstructionist relative to parenting time. There may be some legitimacy to those concerns. That doesn't mean it has to be all or nothing. That doesn't mean it has to be the child never goes or always goes. Two reasonable parents could logically at least consider, in the context of mediation, with the assistance of the mediator, some constructive, flexible brainstorming to come up with something that might match what a neutral court might do if they were presented with an emergency application after each side spends a whole lot of time and money fighting over it. Such as, for example, if there's a case with the example you gave with the child going to Florida, well, there are going to be some obvious issues. Number one, if you're driving from New Jersey to Florida now, the question is, why is it so necessary to do that now when all of the rest stops are shut down? You can't even go in and you're going to be issues with pumping your own gas. There are going to be issues with going to the bathroom. There are going to be issues. What if you break down on the road? Who's going to come and get you? What about the child's health? Does the child have compromised health issues? Some of these children have special needs. Some have asthma. Some have this, some have that. If it's a healthy as a horse 17-year-old, you might look at it a different way. There can be precautions taken where maybe a trip, maybe a closer trip might work. Maybe the grandparents and the parents can come up and meet halfway somewhere else. Maybe there's some other place. Maybe the grandparents can come up here if they're going to the grandparents' house. It doesn't have to be just the child has to go there. Maybe there could be, it's canceled for now, but there's makeup time in the summer or within 60 days after the restrictions are lifted. A lot of times in these cases, at least I find that the parenting issues are not so much, not complicated. It's just each side feels the other side is not respecting them as a parent. They're not, it has to do more with pride and ego than really anything concerning the best interest of the child. And if they feel they are being respected rather than bowled over by the other parent, or shut out in some fashion because there's someone using the coronavirus or anything else to their advantage, then there's a lot more opportunity for there to be some mutual compromise and flexibility. If it's explained to both parties that it's in their, not only their short-term interest to be reasonable, but in their long-term interest, meaning that if a court finds that they were acting unreasonably, that it could affect them in future applications. Some of these cases go on forever. Even if you mediate and settle one, it's like, you know, in Greek mythology, when they cut off the head of the serpent and 3 more heads grow back, keep coming back and coming back. And some people, unfortunately, adopt this as a lifestyle. But if they understand that it's in their long-term interest to demonstrate that they are flexible, that they are willing to compromise, it is better for them as well as for the child, obviously. The first factor in the custody statute under the New Jersey legislature statute is what? Ability to communicate and cooperate with the other parent. Some parties don't even know this. But if you show them this, say, hey, look, this is the first thing a court is going to be looking at, then maybe they can help in their own mediation process and be a little more flexible and come to an agreement that works. If the child doesn't go to Florida tomorrow, is it really the end of the world? Isn't it maybe possible that it makes more sense to consider just laying low for a while, let this thing calm down a little bit, and with the other parent offering makeup time so the trip takes place at a later date? I mean, heck, everyone's canceling their vacations now, right? Everybody is. And so why would a court send a child to Florida to appease that parent? I mean, they might, but there's an equal chance they might not. So why take that risk instead of coming up with some logical solution and increase the makeup time going the other way? So there are all kinds of things you can do if you lead the litigants to their own conclusions. But sometimes they're so close-minded, unfortunately, because they haven't thought of certain things, that all they do is fight and reach a conclusion that the other side is trying to take advantage of them. And sometimes both sides feel that way. So
okay, before we do the next issue, let me, there's a question and I couldn't find it right off. Are you finding that, or let me backstep. My normal mediation sessions used to be an hour and a half. Are you finding that online mediation sessions are shorter than that typically, or are they the same, or whatever you normally did?
I haven't noticed a significant change. If anything, because the couple are not distracted, as long as they know this is the amount of time that's been allotted, I found some mediations going on longer, especially with review of certain items, but it's a more comprehensive way of being able to complete a discussion or complete a review without having to reschedule something for another 15 or 20 minutes. And because they are there as a captive audience, they're comfortable, they've made alternative arrangements. I'm finding that that generally there isn't a significant decrease in attention span. If anything, the attention is more focused.
I think it's a function. I think it's a function largely of the fact that now I'm seeing people, and it isn't like I have someone in the waiting room right away, and I would have to end the session based on my schedule as much as theirs, or my office is in Manhattan, and people are coming up at lunchtime. They have to get back to work. Now, with that not happening, I think the sessions are more open-ended in terms of how much time we need. Perhaps that would have been a good way to work all along, but my schedule and their schedule never allowed it. But there's another thing. Larry mentioned makeup time, and I just made me think, in my agreements, we don't even, when people start talking about makeup time in the course of a normal mediation, or what if I have to miss it, I tend to discourage it, often seeing it as something that's going to be very hard to keep track of. Someone's caught in traffic for an hour, you know, on the bridge or something. Do we use makeup time? But I think there's going to be a new category going forward with mediations that just occurred to me. I might want to talk about, do we want to deal with the issue of catastrophic makeup time? I just made up that term. Catastrophic makeup time is the need for makeup time caused by a catastrophic event. So in one situation, a parent is away with the child, and let's say they got stuck and they couldn't get back from Europe, for example, and now they're saying, the other parent's saying, well, I should get makeup time, and that parent might say, don't be ridiculous, this isn't makeup time, I couldn't get back. I mean, and then you get people having all kinds of opinions about that, but maybe as mediators, we need to think of a new category of what I'm now calling catastrophic makeup time, not just because I have to be away for a day work. And this is, as we all know as mediators, not a simple issue generally, the issue of makeup time. Do you make up 2 hours? Do you make up a day? Do you make up a weekend? Now we're talking about making up weeks or longer. So I think this is something we need further to talk about as mediators and decide how to deal with it with our clients.
Okay, let's move on to the next topic. And
just Carl, just one quick thing. With the COVID-19, remember, if you have a situation where both sides are housebound, and let's say they live reasonably close to each other and the children are not going to school, you could consider a situation that perhaps wouldn't work in another situation, which is a child could go back and forth more easily in that fashion, so long as both parents have an ongoing obligation to oversee the schooling which is taking place during that time. You know, a lot of non-custodial parents, they want all this extra time, but sometimes they're doing it some parents are simply doing it for the recreational time, et cetera, and they're not really doing the tough work, meaning schoolwork and homework and all that kind of stuff. So you have a parent who is willing to step up to the plate in that fashion and wants an opportunity to show it. It could be a win-win for both sides, because then the non-custodial parent has the opportunity to do so. It's not interrupting school. It's not interrupting, you have to go to sleep at night to wake up to get on the school bus. And it gives some respite to the original parent so that they can have some time without that child to do whatever else they have to do, clean or do whatever they have to do. And so there's opportunities there, as long as everyone understands that it's not setting a new status quo. That's the biggest problem. Everyone thinks it's going to set some new status quo, so there's a resistance. As long as it's clear as a bell that this is only temporary in the context of the COVID situation, that type of situation might actually work, where it would be much more difficult in the pre-COVID or perhaps post-COVID world. So
Okay.
just something to consider, yeah.
Next issue is financial issues, the impact of the pandemic on alimony, child support, I guess an equitable distribution. And Steve, you're going to address that.
Well, as I mentioned a little earlier, we're having the after effects and the ongoing effects of COVID-19 affecting financial issues between the parties. It was difficult enough prior to this for a couple who were living in the same residence to be able to make ends meet, living in two completely separate residences with the same income and the same situation. One way that one might have been able to help the situation that we always explore with clients is what could be done as far as getting a second job, finding more. A lot of those things are not even something that people are considering these days, because people are being laid off, much less looking to take on additional work. So what was difficult before has become increasingly difficult now. And couples are needing to consider both what the situation is in the short term, while they are staying in place, what the expenses are that they have each wherever they happen to be. Many families are being separated as a result of the staying in place, or changes that have been made. One spouse moved during the process and they're not going back. So there is a new financial reality. And not only is that something that we can address and discuss with existing clients who are going through the process, but because of the changes that have been worked on clients recently, past clients will be and have been calling to try to modify their arrangements based upon the new reality, based upon what the situation is. So whenever you have a situation such as loss of income on the part of one parent or both parents, that creates additional issues. Many people aren't aware of certain benefits that are available to them through either state or national legislation, and whether we feel comfortable as mediators pointing those things out and explaining that as it affects their particular situation, or at least making them aware that there are these additional loans, grants, subsidies, paycheck protection program in place, that's another aspect, I think, of the services that we can offer our clients. As far as the equitable distribution end, as I mentioned earlier, many people who had a financial cushion or who were very happy to ride the stock market up, all of a sudden are realizing that that what they had a month ago, they no longer have. And that has created a number of additional concerns, not only with respect to existing clients that are in the process of mediation, but also former clients or clients that have been riding for a while that now need our services to address those questions also. So I think the important thing that we need to do now is to enhance the practices and the services that we offer so that we can address and meet the demand that clients have in this, with respect to these various financial, tax and other issues. And everything's thrown into disarray. And there are extensions on taxes. The COVID-19 has brought about many financial changes that we as mediators not only need to be able to continue to hone our skills on delivering mediation services, but also on what is happening out there and what some of these options are that are available to couples and to families to help them deal with the financial aftermath of this.
Yeah, if I could say something on that, follow up on Steve was saying. See, at least in New Jersey, the general law is that if somebody has a change of circumstances, a loss of a job, traditionally, a short-term change of circumstances would not be enough to warrant a major change in support. They recently amended the alimony statute, and with child support, traditionally you had to be out of work a long period of time to establish that it's been a change. But that was under the theory that, well, can't you go out and get another job? In this situation, if you have lost your job as a result of COVID-19, I think it would be a stretch for any reasonable court to think that you're in a position now to go out on interviews for a position when the whole world has been shut down. And so it's a very different situation. And to apply the old laws in this type of situation is like trying to put a round peg into a square hole. The fit may not be there, even though the language may be there. And so when litigants are trying to work out a situation, when someone has lost their job, let's say they were the sole provider or the principal provider in terms of support, whether it's child or spousal support, there has to be some balanced logic and fairness in an approach, either in mediation or, if it doesn't succeed in mediation, in court. It can't be everything goes to one side and the other side has nothing. So it just would be completely inequitable. And family court is what? A court of equity, right? A court of fairness. So in the context of mediation, when you're talking about temporary resolutions, if somebody has suddenly lost their job, they're applying for everything they're supposed to under this new aid package, whatever, but everyone's income is going to go down, let's say in this hypothetical. There might be some logic in doing some type of a pro rata adjustment so the pain is spread between both houses so that everyone has something to live on, but nobody's left holding the bag, or making hyper-technical arguments from old law that doesn't really apply in this type of fact situation. Cases like Lepus did not come out in this type of factual situation, obviously. And so when you go into court, you have to expect that there's going to be that hopefully a court will have some logic and reason and common sense behind, mutual fairness behind whatever rulings they have. So when it's put like that to litigants in the context of a mediation, especially a voluntary mediation where they weren't forced to go there by the court, where it's all consensual, private mediation, and they start realizing that there's a duty for each side to be fair to each other, that is what a court would expect or gravitate towards, then the ability to divide up whatever reduced income has taken place as a direct result of COVID-19 becomes more of a practical reality. You can ask, as a mediator, you can ask each litigant, if you had to write your own order with one stipulation, it had to be fair to both sides, what would you write? And sometimes when you phrase it like that, they're not so willing to come across like they want absolutely everything and the other side gets nothing, because it makes them look unreasonable. Nobody really ever wants to look unreasonable. Most reasonable people do not want to look unreasonable. We have to assume most people are reasonable. It's not going to settle every case, but again, if you can position the parties to get to the reasonable right conclusion, you have a better shot, I think, of success in this COVID environment than you would just leaving them up to their own devices.
And the other thing, as far as the child support, speaking from a private professional mediation standpoint, oftentimes mediation clients will come up with their own desired arrangements with respect to that in our state. And I know we have people listening in from other states as well. There are in the child support guidelines the opportunity to have an exception be made to the child support. Oftentimes, people worked out and mediated exceptions to that and put them in when the financial situation was very different from what it is now. So we are going to see a host of couples coming forward because of these differences. And please, again, everyone, realize and bear in mind, we're talking about courts and we're talking about how the courts would handle it. Right now, courts and the access to the court system is on hold. So this is a perfect opportunity to be able to address and position ourselves with respect to these items and actually help people work out the terms. And even if there isn't at the end due to the court's closures, a final judgment of divorce or a judgment of divorce from bed and board, which is the closest thing that we have here in New Jersey to a legal separation, even if the courts aren't open now in order to be able to issue a final judgment based upon the terms of a settlement, it doesn't mean that we cannot still continue to help our existing clients and new clients with creating settlements that can be entered into during this period that once the courts are open, again, can be submitted. And I'm aware a number of clients, when this started to break, have had judges issuing divorces telephonically rather than in person. Now, there are a number of changes that are going to be taking place and in the interim, but bear in mind, we as private professional mediators and even court-annexed mediators like Larry can still assist our clients during this period in terms of helping them to resolve parenting issues, financial, tax, legal, insurance, and other items, and still come up with a final settlement agreement, even if it cannot yet at this point be incorporated by reference into a final judgment or a judgment of divorce from bed and board. I just wanted to reiterate that.
Yes. And also, and you had mentioned, Steve, before about restraining orders. Just note, if there's a domestic violence restraining order in place between the parties, you can't mediate. There's a pilot program they were just going to break out in New Jersey to allow it under very, very restricted, limited conditions to allow economic mediation with the restraining order in effect. But that, to my understanding, has been suspended as well as a result of the COVID-19. So to the best of my understanding, if there's a restraining order in effect, you should not be mediating that case at all, even if the parties are kept separately, at least not at this particular time.
One thing that I asked couples to do, or asked them to do before, when restraining orders were being heard and emergency orders are still being heard by the courts, is to ask the judge to make an exception for mediation. And some have, this was before COVID-19 as well. But
right. But I'd be careful. I know there's I know people take different views or interpretation of law, and at least my own is you're not allowed to do it, period, even unless you go through specifically the economic mediation pilot program, which now I believe has been put on hold because of COVID-19. And I think there's a risk if you engage in mediation with the restraining order, in fact, is a big risk. It's basically improper without getting court approval first. But anyway, I believe it was suspended, so it becomes a non-issue at this point. You can't do it even under the pilot program.
So let me turn to some of the questions now that people have asked, since we are now an hour and 10 minutes into this. So we've asked a few at the front. Catherine Newcomer asks about security issues on Zoom. I'm going to defer that to next week, but Zoom has taken some actions already. So for example, any new meeting, any new webinar that you establish now has a password. You didn't have to do it for this one because it was scheduled prior to when they made that change. Plus, we don't use a common meeting number. We have a different meeting number for each one, so it wasn't applicable to this one. But we'll talk more about that next week.
And you also want to make sure when you're doing these mediations, I've heard stories of people doing their first Zoom mediation, but you got to make sure that both sides are agreeing that nobody else is in the room, that nobody else is on camera, that type of thing, because you could be violating the confidentiality of the mediation. So you should have, I think it's a wise idea to have that in the mediation agreement up front. And Carl, I think you're going to be talking about that to some degree at one of the next webinars, right?
Here's a question, sort of a generic question, I think would apply even before. Would you ever refuse to draft a provision if both parents want it there? So I don't know.
What an example,
kind of
example of that be, Carl?
Well, here's an example that came up before COVID, which was both parents agreed that they will not send their child to college. Now, they have an obligation to do that. Would you put that into an agreement? I think most mediators said, yeah, they would do it after having advised the clients that that's probably not enforceable. I can't think of any other situation. What did specific on COVID? Yes.
What I've done, oftentimes in the course of mediations, we get couples who are saying they want to agree on something that we feel might not fly. Had a situation where had a client and his wife, they both agreed there wouldn't be any child support paid, and instead the husband, the father would provide the mother with a new Jeep vehicle to be able to drive the children around in a safer vehicle. And I pointed out to them that this is unlikely to pass muster, and they insisted, we want it there. So I said, I'm putting it in there, but I made sure to go over it with them several times so that they understood that that it wasn't. And when ultimately that was the case, it wasn't for want of my telling them not to. If there's something that they are proposing to have that that I think might be questionable, I will, in the memorandum of agreement, specifically put in language to the effect that Tom and Nancy have requested the inclusion of this particular item. I need to address with them issues and concerns that I have with respect to that before it's included, and then I get buy-in from both of them in writing, that they were aware of it, and they still want to have that in there. Again, just from the standpoint of protecting yourselves as the mediator from someone later coming back and saying, why'd you put something in there that ran counter to public policy or that was unlikely to be the case?
Okay. Here's another one. Do you find that Zoom has caused clients to stop communicating with email so it cannot be used as evidence against them in the future?
I haven't heard that come up.
I can't imagine that. It's hard. I understand the theoretical question. It's hard to imagine that. And I guess the other thing is, did we say that the people can't record the Zoom session themselves? Are we recording the sessions? Should we not be? I think we should deal with those questions next week. And how people are going to communicate or not is rather complex. I wanted to say something about the child support point that came up before, I think, well, if we're in the middle of finalizing a child support arrangement with someone, while one or both people are not receiving paychecks or not receiving their full paychecks, I think we have to talk about an interim arrangement.
Yeah.
And stable employment. We would try to do that, I believe.
Yeah. Yeah.
Okay. Let's, I think also there's a misunderstanding. This is something I'm planning to put a webinar on. The difference between confidentiality and privilege, what is confidential and what cannot be used in court. That's privilege. There are two different things. And so that needs to be talked about in the future. Someone wants a cite to the Ontario case. And if anyone has access right now, if you could just get the site and put it in this Q&A, I'll provide it to everybody. Let's see.
I think that was circulated through NJAPM just a couple days ago.
But there may be people on this webinar who
Right.
are NJAPM members. So if anyone has that, does Zoom make it easier for participants to walk away if they are disappointed with how the session is going?
Yes.
What do you mean by walk away, Carl?
Well, I
What do you
think
mean
they
by walk
leave the meeting. Leave the
They
meeting.
push a button.
They just say,
Of
I'm done.
Yeah.
And
They push a button.
yeah.
So it's a lot easier, but that's why sometimes in that situation, if that's the type of friction-filled situation it is, you deal with them separately. They don't have to be in the same Zoom conference at all times. I've done several by caucus, they call them tri-caucus, different caucuses throughout the day, so that doesn't become an issue in those types of cases. If in person, they have to do a whole dramatic act to walk out of a meeting, and then you have to go convince them to come back in, and there's the whole routine, But here it's just pushing a button. So yeah, it is easier for someone to disconnect. That's why you got to be careful when you make a decision whether you really want them on the screen at the same exact time. Sometimes, even though they're not physically in the same place, just seeing each other's faces could set off the wrong energies. Let's put it that way.
Right. Okay. Another question about security of Zoom. We will talk about that some more. One of the changes, at least one of the settings that you can use, is with respect to screen share. And in these webinars and in large meetings, you should always turn off the ability of participants to screen share, because that's one of the ways they can Zoom bomb you. So the only people permitted to screen share on this webinar are the four of us. No one else can do that. Is arbitration a better alternative to reach a resolution, even temporary, as it can also use virtuality versus courts?
It could be in the right case, but what's interesting, if you have a mediation that is unsuccessful on the interim issues, you could arbitrate the interim issues. So it's almost like doing a pendente lite application. You can't get into court right now really to do that, or you can, but it's very difficult to do that. So you could do kind of a partial arbitration. You can stay in mediation, but as part of your agreement of mediation, you arbitrating just the interim issues if the mediation is unable to resolve that. You just got to be careful when the same person is both the mediator and the arbitrator, at least in New Jersey, there are all kinds of potential conflict issues with that under a case called Minkowitz. And so you got to really dot your I's and cross your T's if you're going to do something like that. Sometimes it's better to use two different people for that process.
During mediation, should you disconnect the chat function? Well, if you have two parties, I don't see much of a point of having chat. And I guess you could do it in the settings, and we can talk about that next week as to how you actually do that.
But so, Carl, do you want to just quickly mention with Zoom and if assuming it's a three-party conversation, the difference between Zoom Basic and Zoom Pro relative to the timing aspect of it?
Well, let me talk a little bit now since we have 10 minutes left, and if I don't need all the time, we'll come back and talk about this some more. Next week, Anju and I are putting on a webinar on Zoom for beginners. And that'll be on next Monday at noon. And so we are going to be talking about technically how do you use Zoom. We'll be going through it from the very beginning of what plans are available, et cetera. And so this is an opportunity to use the share screen. So I have the share screen. I can now bring it up. And let's see, where am I? Okay. So, okay. So can everyone see the screen?
Yes.
Okay. So this is a screen that just shows you the basic plan, which is free, the $14.99 plan, $19.99 plan. We'll be talking about that next week. So that's the very first thing you need to do. We'll then be talking about, once you've signed up for it, how do you actually set up a meeting? So you go through it from the beginning to end, how to schedule it, what's important to do, like schedule a new meeting. You know, how do you fill in these boxes? Which ones should you say by default? For example, enable join before host. Something you would not want to do for your clients. You don't want your clients to be there before you are, because it's a great possibility they could get into a real dispute. Then there are settings. There are whole bunches of things here that you need to consider when you set up your meeting or webinar, and we'll go through it very slowly so that you can set up your own meeting and be ready to go. It is not complicated. It takes some going through, but if you go through it slowly, and one of the nice things about Zoom is they have great tutorials. So for example, here's a tutorial in Zoom about putting an attendee on hold. And this would be something that you might use when you're going to have a caucus. So you can have two parties and you can put one of them on hold so they can't see or hear what you're doing. You know, so these are all features that are there. And even at the end of next Monday's Zoom on tutorial, you won't know everything, but you can certainly come back to either looking at the recording again or going to the Zoom tutorial. So that's the kind of thing that we are going to do next week. Now I have a couple of, can people see that Q&A on the screen? No. Okay. I'm now going to stop that screen share and come back to another one, which is next. I'm planning on doing a few more webinars. One is I'm looking for someone to be on a panel, one or two people to be a panel, talking about privilege, confidentiality, mediator notes, special provisions with respect to COVIS to go into mediation agreements to mediate. And this would be a panel discussion on those specific issues, because I think there's a lot of confusion between privilege and confidentiality and what you need to be worried about. For example, who needs to sign the agreement to mediate? It becomes even more important when you have people who aren't online and you haven't had them all in the room to sign things. How do you get that accomplished? So I'm looking for a person or two to present that with me. Another topic that Ken has now agreed to do is we're going to do a series of online mock mediations. And we're going to do this for a couple of reasons. One is to show people how it actually works to have an online mediation. And the second is to show how different experienced mediators actually mediate. You know, there are not a lot of opportunities for us to watch other people. So the thought is that we'll start off, we need another person, Ken, myself, and another person, preferably a woman. And we're going to schedule that and we will start doing that. But I would like to rotate different people into the mediator seat so that we can see what skills they bring to it. And we can all learn from that experience. Also, if people have ideas or have cases that they've had trouble with in the past, or they're having trouble with now, different ways of approaching that case to see, you know, so you get an idea of different ways that you could do it. So,
Carl, I would call that how to break impasse, perhaps.
Well, it might be an impasse situation. Yeah, it
Or
might
difficult
be.
case. What techniques do we use when we're stuck, basically?
It could be that. It just could be, you know, I don't think I handled this situation well. It didn't go well. What could I have done better?
Mhm.
And we can role play it. We can have suggestions. We all have a lot of time now, so it might be a great time to have some learning experience. So, yeah.
There was one question that was raised by Bruce Matez that didn't get answered, and I think it's an important question that many people had. He asked, what can we add to our mediation agreements regarding online mediation? And while there are a number of things that can be added online in terms of changes, wording with respect to the processing of payments, whether it's through a credit card or through PayPal or something else, and indicating to them that they need to have a secure access and they need to turn their phones off and block, make sure that other people are not in the room or overhearing the mediation, having a complete absolute prohibition on their recording the mediation. I had a client the day before yesterday who, in going through the mediated agreement, indicated, "Oh, we don't have to do that. Yeah, I just took a screenshot." And I reminded him that in the online mediation agreement that I had sent to him, it specifically proscribed that. And I said, "You don't want to be in violation of that, and it remains completely confidential." He said, "Okay, I'm going to erase it." So so there are a number of things like that that need to be in a separate or mediation agreement or added to the mediation agreement. Now, for those people who have who are in the process of mediating, you already have sent out an agreement to mediate. It's even more critical at this point to have a separate online agreement or an addition to that, because there are a number of important considerations to doing online mediation that you're going to be speaking to next week, that you need to make sure, since they're not covered in our existing agreement, not to let that slide with our existing clients. So even for existing clients that I had an agreement to mediate, I'm sending out a completely separate agreement relating to online mediation, because it's important to make sure that that is separate. And if you are starting out with someone brand new, I still would recommend having a separate agreement. But if you're dealing with existing clients, absolutely make sure that you send out an additional agreement to mediate online before you conduct the mediation.
Right. We have a form we're going to be able to download. It was a form developed specifically for ongoing court cases for COVID-19 online mediation, but you can probably adapt a lot of the language pretty easily to your own situation. It talks about confidentiality and not having anyone else in the room and all that kind of stuff. Carl will be able to attach that and they'll be able to download that?
We'll find out a way to do that. Yeah.
Okay. All right.
Okay. Now I've asked for a couple of different things, and let's see. I've now gone back to screen share, and unfortunately, there's no way for you to copy. That is the link to the case, case that everyone was interested in. Now, also, I have asked for volunteers to put on a webinar on confidentiality, privilege, provisions to go into agreements to mediate, etc., plus the one for a continuing series of mock mediations. I would like you to send it to me at carlcangelosi@gmail.com. Okay, everyone can see that. This is a great tool for online mediations because I'm a huge proponent, always have been a huge proponent of using flip charts. This is the online mediation equivalent of a flip chart. So you can do what you can do is the same types of things. They also have a whiteboard function. We'll be talking about more of this next week during our Zoom webinar. So again, if you want to volunteer, and I need some for each of those 2 webinars, please send me an email at this address. Okay, and that's that. And we have now reached the end of our time. I want to thank each of our panelists. I think it was really great. I think that, by the way, the attendance, I think, got up to around 56, which is very good. And I think everyone learned a lot from today. So thank you very much, and thanks everyone who participated, and let's see.
Thank you for having us, Carl. Thanks for everybody who joined in.
Yeah,
good luck to all.
And
please sign up for next week.
Let's take this opportunity now, while the courts are closed, while people don't have access to any other venues for addressing their disputes, to provide them with the opportunity to be able to address their mediations online, and to make this not only an alternative, but the preferred way of addressing and resolving disputes among the public.
I think this is a tremendous, thank you, Carl, and thanks to the other panelists. I think this is a tremendous opportunity, and NJAPM needs to be one of the groups at the forefront of letting everyone know, as Steve just said, that this is the preferred way. Let's be clear about that.
And for those who celebrate, happy Easter and Passover this week, and all other things which you're celebrating in these challenging times.
And we will all get through this.
That's right.
Take care, everyone.
Take care. Bye, Carl. Thank you.
Bye-bye.
Bye.